Hello, all. Welcome to another session of Legal Essentials for Human Resource Management. Now, if you remember, this is a course that intends to provide much required legal acumen for anyone and everyone who deals with human resource at workplace. Now, this is week 5 and we are gonna start session 21. If you remember what we were discussing over the course of time, the first week was dedicated to develop some of the basic foundational understanding of concepts, definitions, and ideas of labor law. We discussed how constitutions act as the background or a bedrock for all these laws. We looked at how labor laws have been evolved over the years, looking at the changing workforce nature. We have discussed certain definitions that you should be completely aware while handling human resources. Now, week 2 was dedicated for discussions on contracts as well as few other early job features. So the whole idea is that this course follows a life cycle of an employee beginning to end and initial part of the employment. So an employment contract and everything related with it was what we discussed on week 2. On week 3, our discussions were on wage. We looked at the definition of wage, what is wage, what are the components of wage, types of wages, how wage is fixed. And also we looked at certain other components that go along with the wages as a salary. On week 4, we extended the discussions onto various social security provisions which are available for employees. We discussed Provident Fund, we discussed Employee State Insurance Act, and a lot of other acts like gratuity. With a foundational understanding of all this, let's move into week 5, where we would be discussing a little more about various social security provisions as well as well-being provisions. So that is our game plan for week 5. And let me kickstart the first session of this week, which is session 21, with the discussion on a very important act called as Employee Compensation Act. Now, we know that since an employee spends a considerable time at his workplace and sometimes he is involved in various occupation that possess a threat to certain health contingencies, injuries that may lead to certain disablements. So who is responsible for such incidents? So all those things this act covers. This act beautifully explains what is an industrial accident, what are the various types of injuries or disablements that you can have at workplace, and depending upon what kind of disablement you had, who has the liability to pay compensation for it. Beyond that, beyond mere injuries, there could also be death that happens. This act also covers provisions regarding death. So without much delay, let's get into a comprehensive understanding of Employee Compensation Act. And given the depth of this act, I might take one more session to complete the concepts on this act. So with that on mind, let's start our week 5 session 21 which is titled the Employee Compensation Act. As you might be knowing by now, my name is Dr. Amish Samalopanan and I am from Nalsa University of Law, Hyderabad. Now, before getting into the depth of this act, let's understand the concept of industrial accident. What is definition of industrial accident? So, industrial accident is defined as something that causes a serious job related injury and usually happens on a work site such as a factory floor or a construction site. So there are two key elements to this definition. One, it has to be a job related injury and it should happen on a work site, and you should notice that usually word also. So any work related, job related injury that happened at the work site is industrial accident. Now these words are subjected to interpretation. The courts have interpreted it also in various case laws. We will discuss that in detail. But to begin with, these are any job related injuries that happened at the work site. Now it can range from a minor injury, a small bruise, a small cut, to a major disaster that can affect a large population. So it could be the scope, the extent or the range of the accidents is huge. It can be from a small cut on the body of one person to a huge catastrophic disaster that have affected a large population. Now, what causes these industrial accidents? It's very important to understand. So, I also use this session as a mean to promote safety at workplaces. So, you understand this this unit or this topic. It's not just that you'll understand the provisions of compensation, but you'll also understand why safety is so important and the need to have safe workplaces. See, we started off our course discussion by saying that the primary objective of this course is to build dignified workplaces. And the bare minimum of a dignified workplace is to have a safe and secured workplace where the worker can work without the fear of physical injury. So, with that in mind is where we should approach this Employee Compensation Act. Now, what are the causes of this industrial accident? First, of course, is unsafe conditions. A lot of workplaces often have insufficient workspace lighting. They are working with sharp tools, but there is no enough lighting, and that will end up in an industrial accident. Excessive noise, slippery flooring, extreme temperature exposure, inadequate protection when working with machines or any hazardous materials, unstable structure, electrical problems at the factory, machine malfunction or failure. So all these issues, all these problems emerges from the condition in which the employee was working, hence called as unsafe conditions. But you'll see that sometimes the condition was safe, but the person who was involved was indulged in an activity that is deemed to be unsafe. So such reasons are called as unsafe act. So the actions or failures to act which results in injury, or simple terms, any accident that happens due to employee negligence, that's called as unsafe act. So often employee compensation is a tussle between determining what is the real cause behind the industrial accident. Was it an unsafe condition or an unsafe act? later going forward, you'll realize that sometimes unsafe act emerging from the negligence of the employer can also be possible. In that case, also you deem that the condition was unsafe. So I hope you know the definition of an industrial accident by now. What is the range of industrial accidents that is possible, and what are the causes of industrial accidents? Now you can classify industrial accidents on the basis of where it happened. So if it happened due to a fire, chemical spilling, a toxic gas emission or a radiation emission due to organizational error, human factors, abnormal operation conditions, natural forces have happened, flood happened, storm happened, software or component failures, or outside interference happens, it is called as external cause. Now, this accident happened due to an external cause if these are the conditions. Now, accidents can be internal also, internal causes also. So, it is attributed to be an internal cause if it involved equipment or other work related tangible, harmful materials, toxic chemicals, and human error. So these are things which the employee was supposed to work with, and while working with them, an issue happened. It's an internal cause. If factors are beyond his usual operations, the employee was supposed to bill the various purchases. His job was to collect the bill, enter it into an Excel sheet. Now, in that process, something happens, it's an internal cause. But then the software glitch happened, or there was an electrical short circuit, and then this person gets a shock, leads to a disablement, that becomes an external cause. Now, you should understand, when is prosecution likely? What kind of accidents does prosecution happens? So in case of an accident or dangerous occurrences, especially if it is a major accident, let's examine a limb is lost, or multiple people are involved in this. So often it is the degree of accident that leads to prosecution, or the lacunae is so obvious that the concerned government official has to take a cognizance. For example, there were a lot of compliance, safety compliances that were violated while handling this matter, and it is so on the face that there was a very non-compliance to the peak. In this particular case, then the government official has to take cognizance. Or when a fatal or a major accident occurs and there are a lot of lacunae relating to compliances in the factory, then also prosecution is almost certain. Now let me ask you a question. Now you understood a basic understanding of accidents, industrial accident. You've also seen external causes, internal causes. You have also seen, does it arises from the employee or the employer, which means that is it the context or the employee driven reason. With that understanding, let me ask you a question. Maybe you can just click the pause button and read the question, think about it for a moment, and resume the playback while you have an answer. So the question is, if any employee comes completely drunk and he starts operating a machine and causes an accident to himself, is the employer liable? The guy was clearly drunk. He was taken to the hospital due to the accident where a blood test was done, and then there was clearly more than allowed amount of alcohol in his blood. Uh, is he who's liable here? Think about it. Once you have an answer, come back. Now, the same discussion happened in Gujarat High Court, where the position the court took was that a prudent industrialist should know that the worker can possibly turn up for the work drunk. So the court said, boss, listen, employer is more matured and educated. He should be aware of the fact that there should be certain workers who might turn up drunk to the work. And he should also be aware of the fact that if you are drunk and using these equipments, there would be a huge chance of industrial accident. Hence, it was the responsibility of the employer who didn't keep any checks and balances to ensure that drunk people doesn't turn up for the work. That's a position that the court have taken. So even in case of negligence or misconduct of a worker, if such a scenario is there, an employer is liable for the accident. Employee Compensation Act 1923 is the act which is specifically devised to provide compensation in case of industrial accidents. Now, the objective of this act is to provide payment by the employers to the employees in the form of compensation for any loss or injuries suffered by the employees in an accident. Now, at the time of its enactment, it was called as Workmen Compensation Act, but then later it was renamed as Employees Compensation Act on 2010. And I'm sure you know the reason behind it, because worker only means a specific category of employees, but employees are larger term. So the scope of the act has been extended beyond a regular workman, and now it covers even employees who are in the clerical capacity. Now they are also entitled for compensation. Now the section 2E of this act defines who is employer. So I said the entire act intends to provide payment by the employer to the employee. So who is an employer? So anybody, any person who is governing it, depending upon, it doesn't matter if it is incorporated or not. So a person who's at helm of affairs, which is the employer, managing agent of employer, as well as legal representative of a deceased employer. Now this is to ensure that conflicts doesn't end, or nobody gets saved from not giving or giving compensation due to an instance of death. So legal representative of a deceased employer also is liable, and it also comes under the broad definition of employer. Now, who is a dependent who are lawfully lawful right to get the compensation? So dependent, section 2D defines dependents. So it could be a widow of a deceased person, a minor legitimate child, an unmarried legitimate daughter, or a widowed mother. They are all dependents. It can be a son or daughter who have attained the age of 18 years and is infirm. Now, infirm is a legal term to say that they are not of developed intellectual capacity. So they are mentally retarded. They are not able to function at full mental capacity. So such children, irrespective of gender, and despite having attained the age of 18 will be dependent. A person who is partially or completely dependent on the earnings of the deceased employee. Now, if there was somebody who was dependent partially or completely on the earnings of the deceased employee, including a widower, parent apart from the widowed mother. So, initially we mentioned that it's just a widowed mother, but I'm telling you, the father also, if he was like completely or partially dependent upon the earnings of the deceased employee. In case no parent of the workman is alive, a paternal grandparent and a widowed daughter-in-law. They are also considered under the broader definition of dependent. Who's a workman, which is section 2.1? Really not much relevant right now, given that the scope has been improved. So section 2.1n defines workman. So one who is not permanently employed in administrative district or subdivisional office of a railway, but is a railway servant as defined in the section 3 of Indian Railways Act. Now we look at the classifications of disablements. So the major classification is temporary disablement and partial disablement. Now partial disablement is a scenario where he is still able to function, but some capacity of functioning has been gone due to the accident, industrial accident. The total disablement is a situation where the employee is no longer in a position to function vocationally. Now these are two kinds of disablement. Now within the partial disablement also there is two kinds. One is temporary partial disablement. Now temporary partial disablement is a situation in which the earning capacity of the employee, an employee is decreased due to temporary disablement to perform his duty in the course of employment. So it is a partial disablement, which means that there is a decrease, not a complete takeover, a completely off. No, it's a very it's a decrease in the capacity. That too for a temporary period of time. That is temporary partial disablement. Now it could be permanent partial disablement also. Here the earning capacity of the employee is deemed to be reduced, because that is why you call it as a partial disablement. The earning capacity is not completely gone, but it is reduced. In the first case it was for a temporary period, but here it is permanently reduced. So you might ask, this reduction in the capacity in comparison to what? So both conditions, it is in comparison to what he was capable at that point of time when the accident happened. So I hope we are clear. Partial disablement, two types: temporary partial disablement as well as permanent partial disablement. Now there is total disablement. Now total disablement are also two types: temporary total disablement and permanent total disablement. Now temporary total disablement is a situation in which there is a incapacity of performing any duty as at the time of the accident, but for a temporary period of time. So he is not able, incapacity is the word. So there is an incapacity of performing any duty in a vocational context. It has happened. Now, permanent total disablement is where you lost the capacity to perform any duty for a considerable or a permanent period, and which all disablements are there. There's a clear list. So while discussing various act, I have explained to you that there is schedules which is attached at the end of the act or the constitution, which are tables that clear things up, which has been discussed in the main part of the act of the constitution. So this particular act also has various schedule, and the schedule 1, all this various injuries of permanent total disablement is detailed. In part 1 and part 2 of schedule 1. Now, when is employer liable for compensation? That's a big question. So, in any sort of mental, physical, or bodily injury happens, the employer is liable for compensation. First thing. Second, the accident occurred out or in course of employment. So we told you that the accident has to happen during the employment. But when is the limit? I'll give you an example. I am going for work. I'm not in the workplace yet. I'm on the road. An accident happens. Is it an industrial accident? The answer is yes, because it has happened in the course of employment. I was going for my work. So even if it is going for, even if it is in the course of employment, employer is liable for compensation. Now the injury caused is such that it leads to death, permanent or temporary disablement, or partial or total disablement to the employees, which we discussed in the previous slides. Then also the employer is liable for the compensation. And any other injury that is caused out of employee-employer relationship is also the employer is liable to compensate. With that note, let me complete today's session. We are ending this session abruptly due to the shortage of time. But our next session, which is session 22, will continue the discussions on Employee Compensation Act, and we will discuss closely on this idea of arising out of employment. Because in the last slide I explained that any injury that happens on the course of employment, arising out of employment, is also covered under this act. So we look into certain ways to define what is this arising out of employment. And if time permits, we'll also discuss about Employee State Insurance Act, its benefits, and various compliance related procedures. So with that note, let me conclude today's session. Today we have discussed yet another new act, which is Employee Compensation Act. We first defined what is industrial accidents. Then we looked at what are the types of industrial accidents. Then we looked at what are the causes of industrial accidents. Then we looked at this Employee Compensation Act, and we saw certain definition as per the act, definitions of employer, definition of dependent, definition of what are the various kinds of disablements, and we also looked at when is an employer liable to pay compensation. With that information in mind, let me conclude today's session. Let's meet in our next session. Until then, Thank you so much, and you have a great day ahead. Thank you so much.